come to order. Court is back in session. Ready, Judge?
What?
We are, wait a minute.
So, Judge, at this point, I'll refer to the court's guidance on it, but I know the state intends to call some rebuttal proof. It may be something that's better suited to initially take up outside the presence of the jury, because if they're calling things that we're going to object to is not proper rebuttal.
Okay. Have him go sit down for a minute.
Yes, sir.
What is it that you submit as being going to be addressed on rebuttal and it's not admissible?
Well, Judge, we're not aware of every rebuttal witness they intend to call. There's been some discussions about a deposition that was taken earlier for proof of her name's Miss, I think it's Jacobson, who was the car dealer at the BMW dealership. I believe that to be proper rebuttal. If they wanted to prove what happened at the BMW dealership, they had every right to put it on in their case in chief. They did not elect to do that. At this point, it's not in contest. The expert reviewed her audio statement, said this is what happened. There wasn't even any cross of her to suggest that wasn't accurate about how Mr. Reinking reacted. They asked her if Mr. Reinking got aggressive, or would you agree that was aggressive, or he made an aggressive movement, something like that. The expert said, yep. So that would be one. I don't think that's proper rebuttal.
Judge, the state would disagree with that. She didn't simply concede that it occurred in the way that it actually did. She did say she reviewed the audio of it in making her determination, but Dr. Wood did not concede that he wasn't as aggressive in the way that Jenna Jacobson has already testified on the oath that he was. And additionally, she did not testify about the nature to which he fled from the police. She didn't simply concede that either. And so the state does intend to put that evidence on.
Nature that fled from police.
The police with regard to stealing the BMW. We intend to have the officers who pursued Mr. Reinking as he fled from the BMW dealership discuss, testify rather, to what they observed. There will not be testimony with regard to, they didn't have direct contact with Mr. Reinking in terms of his, having a conversation with him. Obviously, he would have been arrested, and at least 4 people would probably take that alive. But
they're going to suggest that he fled
Yes.
in the vehicle and that they stopped pursuit because of danger to self or others type thing.
they're going to say, essentially, they're going to say they stopped pursuit because of
possible dangers.
yes.
What's it rebut? They had every opportunity to prove the BMW incident in their case in chief. This was not.
Well, they don't
give me a
have,
minute.
well, wait a minute, though. They don't have a burden to prove this.
But they get to choose what they don't get to just come back and put new evidence in or additional witnesses on to prove events that they could have proved. They went into the BMW issue. They could have put that on. It's not, and otherwise it's not rebuttal. There's nothing in contest about it. We didn't put something on and say it didn't happen, or he didn't flee, or that they didn't.
Well, his perception is that they did not pursue him, they didn't come after him, they didn't care. So I think that part is rebuttal.
Well, I mean,
From the officer's standpoint, because he tells the mental health people that part of his logic and thinking is that, he didn't even come after me for the BMW. I'm invisible. They don't care.
Okay, but what is a rebut? So they get up there and say we did come after him. What effect does that have on the evidence that we put on?
The fact that shortly before this, that even though he may be schizophrenic, that he was capable of knowing that what he was doing was wrong, and that this wasn't just a simple retaking of a BMW that belonged to him.
But the whole wrongfulness, this is before the incident. This has nothing to do with wrongfulness. This is before the incident.
It has to do with his general mental state. I mean, we went back to 2015.
Are they rebutting it? This is what I don't understand. If they can say specifically what that evidence rebuts based on what we put on in our defense. That's the
Well,
question.
I don't know what her testimony is, because I haven't read that, although if it's admitted, that last part will, the yellow part will be taken out. What this other person that she apparently knew, who was schizophrenic and had a good job, has nothing relevancy on this, and certainly is probative of zero. The only thing I know for sure is that his perceptions that he wasn't being pursued, that the police didn't care and he had to take matters into his own hands, is rebutted by the fact that he knew the police were chasing him and he took off running and they had to stop. That part, I think, is rebuttal.
Then at best, that's an officer.
But, yeah, I mean, I don't know any of the facts on
I
that.
mean, if that's what the court's gonna rule, which we don't agree with, but if the court says they can put on rebuttal to show that he says, he told them that they didn't come after him, but there was proof that they did, at best, that's a police officer, that's not Jenna Jacobson.
Yeah, I don't know anything about what she's gonna say other than, I mean, everybody agrees that he went and took a BMW without permit.
Not in dispute.
Although his position was, he had a right to take it.
Right.
Okay, and that's where I think the police pursued, he knew he was being pursued. I would assume they were going to testify to that, they put on blue lights or something and then hauled it off, I don't know.
Judge, if we may just give some kind of explanation. Dr. Wood's testimony, she described the BMW salesperson, I don't even think she called her a salesperson, she said it was a girl, it was like, oh, he just took it was no big deal. That is not the testimony of the victim of that incident. It was a carjacking, it was taken by force. So that is the rebuttal. It is also directly related to the motive for these murders and attempted murders. So it has two purposes, but it is direct rebuttal to what they put on through Dr. Wood. They did not have to ask Dr. Wood about that, but they did, and she clearly, I don't even think you can call it minimizing it, she mischaracterized it.
And if I may, Judge, there's a third purpose for it, which is that this will be lay testimony that goes directly to his mind state, close in time to the murders. And that is absolutely an issue in this case. That is what these expert witnesses that the defense called came to testify about. They tell us that he only acted in self-defense, and the state is submitting, we've tried to argue, bringing out through the cross-examination that the reason that he did it was because he stole this BMW, and then the police came and recovered it. It wasn't self-defense, it was anger, it was revenge. That goes directly to the issues that are at the heart of the defense case, for which we do not have a burden. So we have the right to present rebuttal proof in order to argue against or challenge their argument that he was insane. So that's what this proof will go towards.
Yeah, I mean, her testimony, when they're talking about the BMW and Dr. Woods, said that he described that he started repossessing various things because he had a task of collecting what I could salvage of my belongings. He described as repossessing the BMW as well as other items and then having dinner at Logan's Steakhouse to reward himself for his good deed done. So I'm going to allow those two.
And Judge, just for the purpose of the record, it was asked clearly by the state whether he took it by force. And it was conceded by the expert that it was taken by force. So, and this idea of motive, they can put it on to show motive, that's a case-in-chief thing. And the case law is clear that rebuttal is not intended to allow them to change litigation strategy.
No, I agree. I don't find, I mean, that would be argument. I don't, is there anything, I mean, there's no way that the woman could testify that what his motive, what he did there ultimately was his motive for doing anything.
Yes, sir.
I mean, if they want to argue that, they can, but I don't think there's any evidence to support that this BMW incident was motive for him to go to Waffle House and do what he did. So, is that the two that you have? Is there any other?
Witnesses? Yes, Judge, there are other witnesses. We have an individual who testified with regard to the defendant establishing his plan to go and carry out this murder. You want me to give you a proffer as to what his testimony was?
Well, I mean, is there other things that?
Well, I mean,
We don't know what else is coming to know if it's revoked. That's the whole point.
They don't have to lay it out. I mean, you just object when it comes up.
And to be clear, no witness we're calling. Everyone that we're calling has been previously provided to the defense counsel in discovery. So we're not throwing out some.
All right, let's get them in here and get started.
Yes, sir.
Judge, while it's coming, just very quickly on this Jacobson's video.
Yeah, take out the, it's like,
Just to be clear, I don't know if y'all has it up there.
I don't have it in front of me, I left it on my desk, but it asked something about somebody she knew that was totally unrelated.
I would suggest that page 35, everything from line 11 down is what.
I'll be glad to get it off my desk, it was highlighted on the one I have.
Yeah, that's right.
We're in agreement.
Okay.
So we will stop it at that point and provide a redacted copy.
Transcript.
Tomorrow, along with the, yes,
And the transcript was by certified court reporter,
yes, sir.
so it's gonna be submitted as an exhibit.
A collective exhibit with the video,
Okay, but
subject to the
And we'll need some time to redact the video. So we'll have it tomorrow.
But you'll be ready to shut it off today.
Yes, Judge. General Norman is going to be right there on the spot. As always.
Yeah.
finger.
Yeah. I'm sorry. Just for the record, line 11 was forward and the highlights on line 11.
Yes.